Namaskar. I am Dr. Vageshwari Deswal, a professor at Faculty of Law, University of Delhi. We are doing a series on the new criminal laws. Today, we will talk about two new crimes that have been introduced in the BNS, that is, organized crime and petty organized crime. So, to begin with, let us understand what is organized crime. So, when we talk about this term in the general sense, so it means like when criminals they commit crimes in an organized manner. Say like if they are smuggling, they are trafficking drugs, trafficking human beings, money laundering, cyber crimes, etc. So, when all this is being done in an organized manner. So, generally people who are part of some organized crime syndicate plan and engage in systematically committing various activities in furtherance of some criminal objectives. So, what happens? People associate for carrying out any criminal activities, and this is done in accordance with some bigger plan, and accordingly they execute the parts that are assigned to them at different times, different places, but all this is done in a very organized manner because there is a common goal and all steps are taken towards achievement of that common goal. So, section 111 of the Bharatiya Nyaya Sanhita 2023 introduces the term organized crime. It borrows heavily from the MCOCA, which is the Maharashtra Control of Organized Crime Act of the year 1999. Thereafter, Karnataka enacted its own Organized Crime Act of 2000, which was then extended to New Delhi in 2002. Then Uttar Pradesh in 2017, Gujarat in 2019. See, in 2001, Andhra Pradesh and Telangana, and in 2002, Arunachal Pradesh, they have also enacted acts which are identical to MCOCA. Further, Haryana in 2023 and Rajasthan in 2023 have also enacted similar acts on organized crime. So, viewers, you can see that we have so many state legislations dealing with the crime of organized crime. That is when it is done in a very organized manner. But there are some states which do not have such an act, and then this was not a crime in our central laws also. So, as per the 246th report of the Parliamentary Standing Committee on Home Affairs 2023, the existing laws, they were inadequate to tackle the menace of many serious offences like organized kidnapping, land grabbing, contract killings, extortion, as also many major financial scams and large bank frauds. Thus, the requirement for a specific provision relating to organized crimes. Now, MCOCA, it had its own definition of organized crime. Under section 2, subsection 1, clause E of the MCOCA 1999, organized crime means any continuing unlawful activity by an individual, singly or jointly, either as a member of an organized crime syndicate or on behalf of such syndicate by use of violence or threat of violence or intimidation or coercion or other unlawful means, but it is done with the objective of gaining pecuniary benefits or gaining undue economic or other advantage for himself or any other person or for promoting insurgency. Now, in 2023, we got BNS and section 111 subsection 1, it defines organized crime as any continuing unlawful activity including. So you see, when our lawmakers have introduced the term including, what it signifies is that this is a broad definition. This is not limited to the crimes that have been mentioned herein, but this includes this and it could be more. So the crimes that have been mentioned herein, they are merely illustrative, they are not exhaustive, and that is why it says a continuing unlawful activity including kidnapping, robbery, vehicle theft, extortion, land grabbing, contract killing, economic offences, cyber crimes, trafficking of persons, drugs, weapons or illicit goods or services, human trafficking for prostitution or ransom. And when any of these activities which have been so mentioned, when they are undertaken by a person or a group of persons. Now that group of persons might be acting in concert, singly or jointly, but what is required is that they should be acting in concert. There has to be some sort of a planning amongst those people. So when it is done either singly or jointly by those people, either as a member of an organized crime syndicate or on behalf of such syndicate. And how is it done? By use of violence, threat of violence, intimidation, coercion or by any other unlawful means to obtain. Now what is the motive behind this? The motive is to obtain direct or indirect material benefit, including a financial benefit. Now this shall constitute an organized crime. So you see, there are some differences between the definition which was given under the MOCOCA and now this is a broader definition that we have under the BNS. Thus, whenever we talk about organized crime, we should first understand three important phrases. See, these three important phrases, they are important to understand what constitutes terrorist act because they form the crux of terrorist act as has been defined under section 111 of the BNS. So what are these three terms? Continuing unlawful activity, economic offence and organized crime syndicate. See, BNS has defined these terms. So now this is not for you or I to decide what would be an organized crime syndicate. So because what would happen, there would be different interpretations to these kind of terms. So that is why the legislature in its wisdom has categorically defined under the explanations these terms of continuing unlawful activity, economic offence and organized crime syndicate. Under explanation 1, organized crime syndicate means a group of 2 or more persons who acting either singly or jointly as a syndicate or gang when they indulge in any continuing unlawful activity. Explanation 2, it defines continuing unlawful activity to mean an activity prohibited by law, which is a cognizable offence, punishable with imprisonment of 3 years or more. See viewers, it is not every cognizable offence that necessarily entails a punishment of imprisonment up to 3 years or more. Sometimes there are cognizable offences which might be punishable with a lesser imprisonment also. So that is why we needed an absolute clarity here, and here what it says, an activity which is prohibited by law, which is a cognizable offence, it is punishable with imprisonment of 3 years or more. So in addition to being a cognizable offence, it has to be an offence which is necessarily punishable with imprisonment of 3 years or more. So what we are targeting here is more serious kind of crimes that are undertaken by any person either singly or jointly as a member of an organized crime syndicate or on behalf of such syndicate, in respect of which more than one charge sheet have been filed before a competent court within the preceding period of 10 years and that court should have taken cognizance of such offence, and it includes economic offence. So, you see, in order to be a continuing unlawful activity, all the ingredients that have been mentioned under explanation 2, they have to be fulfilled. Anyway, viewers, you know that criminal laws, they are to be interpreted strictly. So, the strict construction of a criminal law, what does that entail? Unless and until all the ingredients of any crime, to constitute any crime or any particular component of a crime, if it has been defined in the statute, till the time all those ingredients are not totally satisfied, it would not be considered as amounting to that crime. So, we strictly have to check that the act of the accused person should be covered squarely within the parameters of the definitions given by the statute. Now, let us talk about what is an economic offence. Under explanation 3, economic offence, it includes criminal breach of trust, forgery, counterfeiting of currency notes, bank notes and government stamps, hawala transactions, mass marketing frauds, or running any scheme to defraud several persons, or doing any act in any manner with a view to defraud any bank or financial institution or any other institution or organization for obtaining monetary benefits in any form. So, here again it is a very comprehensive definition defined in a very inclusive manner. So, section 111 subsection 2. Now, this prescribes punishment for organized crime. It says, whoever commits organized crime shall, if such offence has resulted in the death of any person, be punished with death or imprisonment for life, and shall also be liable to fine which shall not be less than 10 lakh rupees. So, you can see if it results in death of a person, so there is a minimum fine of 10,000 rupees and punishment is only death or life imprisonment. So, organized crime is such a serious crime. If an organized crime that an accused has committed results in the death of any other person, punishment would be very strict, either death, life imprisonment and also fine, and the fine shall be minimum 10 lakh rupees. So, it could be more than that also. Thereafter, what the law says, in any other case, that is where the organized crime does not lead to the death of any person, then in such cases the punishment shall be imprisonment for a term which shall not be less than 5 years. So, you see again it is a minimum punishment of 5 years, but which may extend to imprisonment for life, and shall also be liable to fine which shall not be less than 5 lakh rupees. Under subsection 3, now we are talking about abetment of organized crime or attempting to commit a organized crime, or when you are entering into a conspiracy to commit an organized crime. Because an organized crime is a very serious offence, therefore, abetment of organized crimes, attempt to commit organized crimes and conspiracies to commit these kind of crimes have also been made separately punishable under the provisions of the BNS. So, under subsection 3, whoever abets, attempts, conspires or knowingly facilitates the commission of an organized crime or otherwise engages in any act preparatory to an organized crime shall be punished with imprisonment for a term which shall not be less than 5 years, but which may extend to imprisonment for life, and shall also be liable to fine which shall not be less than 5 lakh rupees. Then under subsection 4, whoever makes any person who is a member of an organized crime syndicate punishable with imprisonment for a term which shall not be less than 5 years, but which may extend to imprisonment for life, and shall also be liable to fine which shall not be less than 5 lakh rupees. Then, whoever intentionally harbors or conceals any person who has committed the offence of an organized crime shall be punished with imprisonment for a term which shall not be less than 3 years, but which may extend to imprisonment for life, and shall also be liable to fine which shall not be less than 5 lakh rupees, provided that this subsection shall not apply to any case in which the harbour or concealment is by the spouse of the offender. So, you see under subsection 5 of section 111, harbouring, concealing a person who has committed organized crime, it is a punishable offence, and punishment is also from 3 years to life imprisonment and also a minimum fine of 5 lakh rupees. But then there is an exception that is available to spouses of such offenders who have harboured their own spouse. It says, this subsection shall not apply to any case in which harbour or concealment is by the spouse of the offender. See viewers, note the gender specific term here. The legislature has used the term spouse. It does not talk about husband. So, it is talking about spouse. So, it is an acknowledgement of fact that nowadays we see men as well as women engaging in crimes. So, whosoever is the spouse, sometimes there is a possibility that the man might be harbouring his offending spouse who is the wife. So, in such cases even the man would be exempted from liability by virtue of this proviso to subsection 5. Then under subsection 6, whoever possesses any property derived or obtained from the commission of an organized crime or proceeds of any organized crime or which has been acquired through the organized crime shall be punished with imprisonment for a term which shall not be less than 3 years, but which may extend to imprisonment for life, and shall also be liable to fine which shall not be less than 2 lakh rupees. Then subsection 7, if any person on behalf of a member of an organized crime syndicate is or at any time has been in possession of movable or immovable property which he cannot satisfactorily account for, then he shall be punished with imprisonment for a term which shall not be less than 3 years, but which may extend to imprisonment for 10 years and shall also be liable to fine which shall not be less than 1 lakh rupees. So, viewers, you see there is a sort of presumption here that, see, if you have any movable property or immovable property, and if you are a member of an organized crime syndicate, but you are not able to account for such property, so it will be naturally presumed that maybe you have obtained such property from the proceeds of your crime or by making money by committing those organized crimes, then again it is a punishable offence. So, you see, the offence of organized crime, it covers a broad spectrum of activities. It prescribes minimum punishment, mandatory fines, and how do you ascertain the minimum punishment and mandatory fines? What the legislature has done? See, depending upon the gravity of the offence, the mandatory fines have been prescribed. The objective is that these minimum punishments, these mandatory fines, they should act as a deterrent. So, this is about the law, but then there are certain concerns. There are certain terms under the law such as land grabbing, contract killing. Now, these have been not defined anywhere in the BNS. So, there is a possibility of an unfettered discretion with the prosecution. Also, since now it will be an offence under central law also, so this may create jurisdictional issues. So, there are certain concerns, but as per Article 254, Clause 1 of the Constitution, if any provision of a law made by legislature of a state is repugnant to any provision of a law made by Parliament, which Parliament is competent to enact, or to any provision of an existing law with respect to one or any of the matters enumerated in the concurrent list, then subject to the provisions of clause 2, the law made by Parliament, whether passed before or after the law made by the legislature of such state, or as the case may be, the existing law shall prevail, and the law made by the legislature of the state shall to the extent of repugnancy be void. So, in view of this provision of our constitution, the article has made it very clear that whenever there is any repugnancy between BNS and that special law which is given under which is a state legislation, then in such cases of repugnancy, it is the BNS which shall prevail. Further, there is no definition of proceeds of organized crime in Bharatiya Nyaya Sanhita. Thus, we will have to understand it in terms of the definition which is given in Bharatiya Nagarik Suraksha Sanhita. Clause C of section 111 of Bharatiya Nagarik Suraksha Sanhita defines proceeds of crime to mean any property derived or obtained directly or indirectly by any person as a result of criminal activity, which would include crime involving currency transfers or the value of such property. Similarly, the term property, it has to be understood as per section 111 clause D of the Bharatiya Nagarik Suraksha Sanhita to mean property and assets of every description. See, this term property, it has not been qualified under the BNS. When we talk about the definition under BNS, we have a definition of the term movable property. In BNSS, the term is property. So, what it says? Property and assets of every description, whether corporeal or incorporeal, movable or immovable, tangible or intangible, and deeds and instruments evidencing title to or interest in such property or assets that are derived or used in the commission of an offence, and it includes property obtained through proceeds of crime. Section 107 of the Bharatiya Nagarik Suraksha Sanhita provides for attachment and forfeiture of property which are proceeds of crime and distribution of the proceeds among victims. So, proceeds of crime that are unclaimed by victims shall be forfeited to the government. All these powers, they are exercisable by police and magistrate even during investigation. Dealing with proceeds of crime, giving relief to victims, these are important things. So, that is why these are matters which are not required to wait till the time there is a conclusion of the trial. So, all these powers, they would be exercisable even during investigation, and dealing with proceeds of crime, giving relief to victims wherever required, that can be done in a very expeditious manner. So, viewers, after talking about the definition of organized crime, let us see how the Bharatiya Nyaya Sanhita defines petty organized crime. So, under section 112, whoever being a member of a group or gang, either singly or jointly, commits any act of theft, snatching, cheating, unauthorized selling of tickets, unauthorized betting, gambling, selling of public examination question papers, or any other similar criminal act is said to commit petty organized crime. So, you see, it could be theft, it could be snatching, it could be cheating, unauthorized selling of tickets, unauthorized betting, gambling, selling of public examination question papers, or then again what it says, any other similar criminal act. See, we have to be mindful that every day new kinds of crimes, they are coming up. So, that is why we cannot have unduly restrictive definitions. So, that is why it uses the phrase any other similar criminal acts. So, it shall be said to commit a petty organized crime. There is an explanation appended to section 112 which says, for the purposes of this subsection, theft includes trick theft, theft from vehicle, dwelling house or business premises, cargo theft, pickpocketing, theft through card skimming, shoplifting and theft of automated teller machines. So, this is also something that we have heard in the newspapers, that sometimes you have gone to an ATM and what you find is that the machine is not there. So, what happens sometimes when people, they are not able to break through the machines, they lift them and they take them away. So, all this would now be covered under the definition of petty organized crime. As per the 246th report of the Parliamentary Standing Committee on Home Affairs, some offences like organized snatching of any movable property, pickpocketing, theft from vehicles by trickery, card skimming, ATM theft, they create a sense of insecurity amongst citizens. So, this is an area that needs to be addressed. Then another issue that has been creating a lot of furore is the large scale paper leakage and other manipulations in public examinations. We all know that there are organized gangs that are operating and that are involved in such incidents. So, introduction of this new provision is pertinent for inculcating a sense of security and maintaining confidence of public in our examination systems. However, some vague terms such as trick theft, pickpocketing, card skimming, now they have created scope for ambiguity. So, for the time being, they would have to be understood as per their ordinary connotations. Few years down the line, we will have conclusive determinations and interpretations of these terms by some higher courts. Until that time, we would have to just wait and watch and understand them as per their ordinary dictionary meanings. Now, how does petty organized crime intersect with other offences against property? See, if the offender committing theft is a member of a gang or a group, then the offence is punishable under section 112. But if he commits it as a lone wolf, that is when he is operating by himself solo and when he is not part of any gang, then he would be punishable under 303. This would be theft. Similarly, for snatching, one who does it as a member of a gang or a group, offence is punishable under 112 as a petty organized crime. If he does it as a lone wolf, again if he does it himself, then it would be punishable under 304. Similarly, cheating when done as a member of a gang or a group, it is punishable under 112. Done by himself, it is punishable under section 318 of the BNS. Similarly, when the offender committing the offence of theft in dwelling house, means of transportation or from place of worship is a member of a gang or group, then again punishable under 112, and if he commits it by his own when he is operating solo, he is not part of any gang or group, then it is punishable under section 305 of the BNS. So, I hope that after this lecture, you are able to differentiate between organized crime and petty organized crime and how this new provision of petty organized crime will be playing out in our BNS. Thank you.